Sometimes also in complex matters, we have what's often referred to as an evaluative mediation or an advisory one. So you have, for example, senior counsel who has a lot of expertise in the substantive area of the dispute, who offers advice to the parties to assist them to reach a settlement in the matter. I think there's, in terms of accreditation processes and looking at standards that are evolving, so for example, I don't know how many people here are aware that the Law Council of Australia has standards for mediators. Is anybody aware? Ever seen those standards? No? No? Lots of shakes of heads. There is also a Law Council of Australia guidelines and standards for lawyers representing parties in mediation. Has anybody seen those? No, lots of shakes of heads. And I think if you look at those standards, it's very interesting because it's definitely a raising of the bar in terms of expectations about mediators and what we could and should expect from mediators as lawyers representing parties in mediation, and also for the parties, etc. But also in terms of what we do as lawyers representing parties in mediations. So I think that there's many aspects to this, and you know, I think when we're lawyers who are going to be representing a party in a mediation, we do need to think about what sort of dispute it is, what type of mediation would be appropriate, because you're selecting the mediator, what sort of mediator you're going to select. And there are different styles of mediation, as I've mentioned, the settlement approach, the advisory or evaluative approach, but also the facilitative approach, which is much more focused on the mediator working with the parties to help them to isolate what's in dispute, to identify options, and to communicate, to basically look at those options and to negotiate those options and arrive at a resolution. To engage the parties a lot more, because the style that we're used to as lawyers is very much as when we're representing parties acting as a spokesperson. But I think there is scope for looking at other roles that we might play as lawyers representing parties in mediation. And sometimes it is appropriate to give the party a much greater role in terms of a speaking role and participating. You often hear very senior mediators saying that they've been involved in mediations, reasonable offers have been made but not accepted, and the parties have become quite entrenched and been very difficult to resolve until they realise that one of the parties had something that they really need to get off their chest and say to the other party. And once they were given an opportunity to do that, they said, fine, I'll take the offer now. So it's creating, I think, you know, looking at ways of creating an opportunity for greater participation of the parties actually in dispute. And so that's something that we need to think about in terms of looking at our disputes, analysing those disputes in terms of what type of mediation will be appropriate, what type of mediator will suit this dispute, and what role should I, as a lawyer representing the party, play? What role does the client want to and need to play? And also preparing the client for that too. They just can't go in cold. There's a lot of preparation. And the other aspect too, given that we're talking about all different forms of mediation today, I think in terms of thinking about mediation is not necessarily going to be the best form of ADR. So because of court-ordered mediation, because it is the most available form of dispute resolution, we tend to think, right, let's go to mediation. But it's not necessarily for all disputes. So it's really looking at the dispute, analysing the dispute, looking at what options are available and seeing what's going to work. And it might be that one or two forms of dispute resolution may be needed at different points. And I don't know whether you're aware, but there are actually hybrid methods of dispute resolution as well, such as MedArb and ArbMed. Is anybody aware of hybrid approaches? Yep, somebody is put up there at the back. Yeah.
Well, just give a description of those hybrids.
Well, one option is arbitration mediation. Now you would think, how on earth would that sort of a hybrid approach work? But what actually happens is that it can be one dispute resolution practitioner who initially acts as arbitrator and then goes on to mediate. So what happens, the arbitration takes place. The decision of the arbitrator is placed in an envelope and set aside. And the dispute resolution practitioner then goes on to mediate the matter. And so clearly the effect of having that decision in an envelope is a factor that plays a role in the following mediation. But it is also possible to do the opposite and have mediation arbitration, so that the mediation fails, then you go on to the arbitration. Of course, it is possible to engage in those hybrid methods and have different practitioners as well. But it doesn't matter, it could be. It depends on the parties, what the parties want. So I think that it's about looking at disputes, what's appropriate, what's going to meet the parties' needs, what's everybody agreeable to, so designing that process, and then working with the dispute resolution practitioner too, to help design what's going to be appropriate. So if there's going to be a mediation, approaching the mediator and say, look, this is the kind of approach that we think we need in this dispute. Is that something that you're able to provide? Is that the service you're able to provide? So I think we've reached a stage where there's a new emphasis on quality. There's a new emphasis on our creativity in terms of how we use what's available, and being aware of all the different types of dispute resolution that are available and that we can access. And certainly, what's coming from a policy level, from our Attorney Generals and sifting through legislation and related to courts, etc., is that from a policy and governmental level, there is a huge increase in interest in ADR.
There's one of the things that you mentioned was evaluation by senior counsel or somebody in relation to the dispute. The court are also offering early neutral evaluation, and as Paul mentioned in his introduction, I was just wondering if anybody has gone through the experience of an early neutral evaluation conducted in the commercial list. Because
describe the process. It's in the Green Book of the Commercial Court. There's quite a section on early neutral evaluation, and when the Green Book was launched, there were, I remember attending one seminar on it by Honourable Justice Jennifer Davies of the Supreme Court. But I've often wondered about the take-up, and this is really what you're addressing now, Mark.
Because it was, as Liz has mentioned, it's one of the options that are available, certainly informally between the parties, but it's also formally offered by the courts now as one of the methods and the flexibility of approach in the litigation process. And it seems to me to be a very good idea, but I haven't had any experience of it myself.
And the idea is that there'll be a particular proceeding in the court,
yes,
and if the parties agree to raise it with the judge, certainly in the Supreme Court this is the process, the judge who's handling the matter then consults with the senior judge of the list, and there's a discussion about whether the proceeding is suitable for early neutral evaluation. And then another judge, as I understand it, is appointed to conduct that early neutral evaluation and to give the parties effectively a non-binding view about how that particular judge thinks the matter will go. And the parties take that and do with it what they will. Is that your understanding?
That's right, yeah, that's my understanding, and I just wondered if it's been used by anybody here, and if so, with what effect.
Is there anyone who's Frank O'Donnell?
Paul, how early was
Well, I think the rules talk about at least the pleadings being closed, and the rules also talk about a package being given to the early neutral evaluator, which will be the critical documents only, so that the judge is not expected to read the whole of the discovery. I gather that there are page limits set on submissions of fact and law, about 10 pages. And as I understand it, the idea, certainly reading the literature in the US, where it was sort of the flavour of the month, and from where we have grabbed it, the parties would have half a day only with the early neutral evaluator. And so the idea being to compress cost and time to get an indication of how things were likely to go. Now, it really interests me, and I've raised this with a couple of the judges in the Supreme Court just to find out about the take-up of it. And I got an interesting response, which was in terms, this is a fantastic thing that should be used more often. How many times has it been used? You can't actually get a straight answer. And so firstly, have there been practitioners who've been involved in early neutral evaluation in one form or another in any jurisdiction in?
Well, I've been involved in a case which is a little bit like that. It probably didn't start out that way, but I think it ended up in a similar vein. And that was in the planning jurisdiction at VCAT, where I had a case which was going to be a very expensive planning case, and the VCAT appointed a mediator to meet with the parties to have an afternoon to discuss the matter, and the outcome of that was the mediator was very strong and very practical, and was able to persuade the parties that these particular issues didn't have any legs. They weren't going to get up. You're wasting VCAT's time going on with them. The mediator accepted that these other issues were really genuine issues that needed to be properly heard. So the outcome at the end of the afternoon was a signed agreement by the parties present, which the mediator scribbled out, they all signed, where the parties agreed that these particular issues were no longer in issue, and these other issues were the ones that had to be determined by the tribunal, and it went on and was determined. We had a great success at the tribunal, but it was just a very practical way of getting to the point of the dispute, and then having those points determined.
How do resident objectors in a planning dispute take to being told that what they think are really substantial objections are really more peripheral things that will not...
In that context, they had their day.
Yeah.
They had they had an opportunity to express their grievances, and they had somebody who had some reasonable authority, the mediator, listen to them, respond sensitively, and then basically telling them in the politest terms, you're wasting everybody's time. And people accepted that, some a bit grudgingly, but they did accept it on those particular issues. But the others that were more important, the mediator was equally strong in saying to the applicant, look, these are genuine grievances, they need to be heard. And so it worked well in that context. And I thought it was a very good example of what can be done perhaps in the more senior courts as well, quite easily.
Well, I think it touches upon what Elizabeth said before about mediation being important as having a sort of a therapeutic effect for parties to have a forum. And I remember, I'll never forget, one day many years ago, a mediation conducted by the late and wonderful lawyer Ron Caston, where I was appearing for a man who had been dismissed by one of the large insurance agencies as a broker, and he had been a hugely successful broker, and was devastated at having been dismissed and required to repay the loans, etc., and enticements which the insurance companies offered to their agents at that time. The mediation ended with a settlement against all the odds. But I remember Ron Caston looking at me rather curiously as my client was hugging Ron, sobbing with tears, thanking him profusely for effectively being the judge and telling my client that he had acted honourably. Yes, he might have been treated unfairly, but he had his day and he had the opportunity or the forum to tell someone about about the nature of the grievance and getting things off one's chest. I don't know what other people, whether others have had similar experiences, but one of the advantages of mediation is the ability for clients to talk in the terms they wish to directly to someone they perceive as being a decision maker or having a certain status. Have others had a similar experience?
I had an experience recently with a plaintiff that's currently involved in a class action, and class actions are sort of flavour of the month at the moment, and I'd really underestimated. They were saying that there's upsides to it, but they just got a little bit disempowered that they wouldn't actually get a chance to have their day in court, and albeit a class action can result in better outcomes for a large group of affected plaintiffs. I think it's sometimes forgotten by the lawyers that clients do sometimes want their day in court, whether or not it's the best outcome, but it's still something that needs sometimes to be addressed, I think.
Yeah.
One of the...
Sorry, was there just one other?
Yeah, I had a similar issue, although it was the plaintiff, it was an IP infringement case, but they had the owners of the two companies there, and the plaintiff really just wanted to stand up, and he was almost in tears when he was talking about the family history of the company and how many Victorians they employed and all this sort of stuff, and it just was quite, I think, cathartic for him to say all of that and say that face to face with the people he thought were infringing his rights. And then after he sat down, you know, the matter resolved quite quickly, and that was a court-ordered mediation very early in the proceedings. And my practice doesn't involve a lot of litigation, but I've been much more open to matters issuing now on the basis that you know that it's going to get referred to mediation straight away. And often you know that it's going to settle straight away, but you can't get the parties together because, for whatever reason, that they're not interested. You know, it's a point of principle rather than a point of cost. But you know that the principles will very quickly fall away when the costs start to mount up. But with the very early mediation ordered by all levels of courts now, you get to that situation much more quickly, and in fact it's probably more cost effective to actually issue proceedings and get straight to a mediation now than it is to follow almost another route.
Well, that's an interesting observation, and the gentleman on your left, Frank O'Donnell, asked me how early is early. I wonder whether mediation, the timing of mediation is important. Is it better to go early at the beginning of a dispute, or are there mediations which occur just too early and fail because the parties are not ready for the dispute to be mediated? When's the best time to go to mediation?
My experience with parties that have attempted to mediate, for example, prior to the commencement of any proceedings, has been generally pretty poor, because they come with, they're still very bound up with the emotion of their case. They haven't had time to properly digest what is being said by the opposing party. Frequently the issues have not been properly articulated and pleadings do really perform a very valuable function, because you actually sit down and identify precisely what is in dispute. And frequently I've had the experience where parties are really want to, or the lawyers more than anything, really want to get a quick resolution because they can see the whole thing spiralling out of control. But the litigants are still, or the potential litigants are still not in a frame of mind where they're ready for a negotiated settlement. They haven't experienced just the sheer cost, both emotionally and financially, of litigation, and I think that that's an important, for all those reasons, it's important to have commenced the litigation, identify the issues, experience what the litigation process is all about, and then they come with, I think, a very different view to the way that they wish to achieve settlement of their dispute.
I think a lot of it comes back to every single case has to be dealt with on its own merits, and as a solicitor, more often than not, the so-called mediation is the first phone call from the client, and the client is just absolutely up in arms about something, or aggrieved or whatever, and what's really happening is the client's getting it off his or her chest by simply ringing their solicitor and having a good discussion about it, and that's it. That's as far as you have to go. And as a solicitor, sometimes you have to be very careful not to be tempted to let it go beyond that point. But then you get, then when it does go beyond that point and it does become a matter that you're dealing with, I think so much depends on getting the facts out on the table. And if the facts can be determined very early, I think the dispute can be resolved very early. But if it's one of those cases where it just takes a long time to really get to the bottom of what this is all about, so that the facts and the issues and the resolutions might have to go through a full process of interlocutory proceedings and so on, just to get to the point where you can have a sensible mediation. And I think so much depends on the solicitor and or the lawyers concerned being able to judge just what is that point, and every case is different.
And the nature of the dispute too. I was involved in a matter a few months ago that I represented a party in a mediation prior to issuing the proceedings, and it did settle, but it was a very discreet legal issue, and probably would have turned into a bit of a test case, so it seemed ideal for mediation prior to issuing proceedings. But I think the general rule is that you think about ADR and you think about mediation at any point. It's prior to issuing proceedings, it's after you've issued proceedings, and maybe the pleadings have closed, but at any point along the way, including after the completion of evidence but before judgment. So it really is, I think, what Michael was saying, it's about you have to look at your particular case and the circumstances, the nature of the dispute, the parties, there's many aspects of it, and there's it's never too early and it's never too late. I think that's probably the general principle.
Yeah. And then there are those cases, I've got a couple at the moment, where there's just no way the parties are going to entertain any form of settlement. It's just going to go the whole way, and so in those circumstances...
The Victorian Bar is very grateful for clients.
Well, those are the cases, the first step I take in all those cases, I ring Michael Green and I say, who's the appropriate person? And it's the only way. You just have to get on with it as quickly as you can.
Have we got to a stage now where the expectation is that a matter will not settle unless it's referred to mediation? Years ago, and Elizabeth alluded to the Spring Offensive in 1992, and as I look around the room, there were people who were still in creche in 1992. I remember it very clearly. And occasionally you hear people say, I don't need a mediator to settle a dispute. I just wonder now whether things have moved so far in the other direction that now practitioners rely upon mediation to settle disputes. Ron, do you think that's where we're up to?
Well, I think Sorry, I think it's happening more often. I don't know that it happens all the time, but it's the sort of soft option in a way. You get the proceedings going, and I mean, I've just got one at the moment in the Federal Court. I think the first directions hearing, Justice Marshall made the usual directions about this, that and the other, including a direction for mediation by such and such a date. And before you can say Jack Robinson, the Federal Court's written to you with a time and date, and neither party has even broached the subject of settlement, because we're all waiting for the mediation. And I think if we hadn't had all that, we might have been talking settlement already, that's all. So I think to some extent we take the soft option. It's going to be mediated, well, let's just get on with it and do our discovery, etc., etc. So I think to some extent you're right.
Rob Ewing, who's in the second back row. Rob, you've been in a position to observe these trends over some years. What do your clients or clients generally think about the cost of the mediation process, and whether if a mediation fails, they regard the mediation as having been a waste of time?
I've never had a client express concern about the cost of mediation, because that cost pales into absolute insignificance compared to the tsunami that awaits them. So I don't see that as a problem. At the risk of not answering the question, I would like to raise a couple of issues that Ron has made and that have also been expressed here, and Frank O'Donnell's comment about how early, etc. I think, and I'm in the context of what Ron's just said, I think there's a real risk when mediation's too early. And one of the reasons why I think that hasn't been raised so far in this conversation, and it's this: I'm a keen but non-practising, but I'm a keen advocate of the fine art of cross-examination. And I think, for example, in the recently settled Centro case, all I know of is what I've read in the newspapers about that, but it seems to me, as just a rank outsider observer, that some really critical concessions were made in cross-examination in that case, which ultimately brought about a resolution. How would a mediation have been effective at the closure of pleadings and prior to discovery and prior to anything much? As I understand it from press material, the range of possible outcomes went up to $1 billion, which is quite a lot of money, and probably well beyond insurance issues and everything else. Is quite a destructive level of compensation. But the practitioners representing the funded applicants wouldn't know those concessions were in the wind, probably. How do they? What use is it mediating a case of that dimension and of that complexity, and so hard fought at an early stage? If it's to be done at all, it's probably best done after cross-examination. And I think that's a huge cost. But there are cases, certainly in my experience, where a mediation would have been pointless, even in hindsight, at the end of a case that's gone to judgment, or in one case been withdrawn. To look back and say this case could never have settled. It had complexities of personalities involved, or sheer size of money, and so on, where there just wasn't an alternative, and an early mediation would have been pointless.
What about within a mediation? Say there's a senior practitioner and an experienced mediator is engaged, and so they're being hired for the benefit of their experience. How do parties respond to a mediator that actually decides to roll up his or her sleeves and expresses a view about things in the context of the mediation? How do clients receive that? Is it regarded as unwelcome, unhelpful, or welcome? What do people think about that?
I would regard it as unwelcome, personally, and in the same context as the neutral evaluation, particularly at an early stage. I think it's an unnecessary an unnecessary intervention, which may give courage to someone who needs all the help they can get.
What about early neutral evaluation, Rob? Would there be, I wondered, some level of anxiety or distrust of the confidentiality of the process within the court itself? I wondered whether that's the reason that people aren't willing to take advantage of this free service, as it were. A judge of the court expressing a view about prospects, one would think, would be a heck of an advantage to clients, and yet clients don't seem to want to take advantage of it. And I wonder why. And do you have any, would you recommend that to a client?
The neutral intervention?
Yeah, by a judge of the court?
No, I wouldn't. I can't.
Why not?
And I've been thinking during this conversation for any reason why I would. My understanding, I'm going back to a seminar I went to some years ago on intellectual property, and the speaker was an American judge, and he said that it was the first I'd ever heard of the concept, which is one of the reasons I went to the seminar, and it was confined to intellectual property cases. So there was a neutral evaluation of the relevant competing claims. I can understand it in that context because there's really quite defined issues you can deal with, and perhaps a person then who's disappointed with the outcome can think, well, yes, but that's because the judge has taken this particular view, and I can understand that, we'll deal with it. But if the case is more an evidentiary case of witnesses and so on, and various issues of fact giving rise to a negligence action, something of that sort, professional negligence action, in the absence of cross-examination, I just think it just unnecessarily worries some of the parties, and for what may ultimately be seen to be no purpose whatsoever.
Up from the back. Thank you.
In 32 years of practice, and I do a lot of litigation, I've never had a barrister suggest to me early mutual evaluation. So that might be one of the reasons it hasn't been taken up by a lot of the practitioners. Yep. You answered one of my questions before, which is, does the court impose fees for it? Apparently they don't. Do they actually have judges available, and what sort of timelines are you going to have to wait? Because it sounds to me like it's something that could be used at the close of pleadings, where you've got, if you're not in the commercial list, you've got 6 or 8 months to a trial date. And if your parties, need some, they might be prepared to look at something like that.
Well, I can't really answer that on behalf of the court, but my suspicion is if the parties were to ask for an early neutral evaluation within the Supreme Court commercial list, you would be on in no time at all. Because I think that the court would like to see use of the procedure and success within the procedure. I know that the former attorney, who was hot to trot about ADR, was certainly pushing early neutral evaluation as one of the accepted methods of dispute resolution, and certainly Justice Bogoni, who did a fair bit of research into ENE, as it's called, in both America and the UK, his observations were that it worked very well indeed, and it ought to be utilised more often by the Victorian legal community. But I think I can't...
Yeah, I take the opposite view, that I think it's a really valuable thing, but maybe that's because of the nature of the cases I've been involved in, or because of the fact of my stance, which I think litigation generally only advantages the lawyers, and the clients really, even the ones that win, usually lose because of the cost, what's happened between the parties. There's usually, it's the destruction of any relationship that might have been there between the parties. And you often find where you've got a mediator who takes that role of picking apart the elements of your case, and you're presuming that in the sanctity of the mediation room he's doing the same to the other side. It allows the client to see what's coming down the track, where the holes that might be in their case, and also more of an understanding of the other side's case, that they might be thinking, why are they relying on, this element? How most clients think the other side doesn't have a case at all. They think, how can they possibly keep spending money on lawyers? What do they think what do they hope to achieve out of this? And sometimes I hate to suggest this, but you query the ability of the other side, and are they just trying to spin it out, or is there something else at play here in terms of an ulterior motive or a different commercial imperative that the other side has that's not necessarily linked with the outcome of the case? And I think that if you do have this third party, this independent person, whether it's a mediator or whether it's something more complex such as the neutral evaluation, it does give the client more of an understanding of where the procedure is heading and what are the strengths and weaknesses. And yes, they should get that from their own lawyers, and there will be situations where it doesn't work, maybe because of the number of parties who are involved or because of the evidence that might be coming. But a lot of the time nowadays you have at least witness statements or affidavits, and yes, they need to be cross-examined. But it from my perspective, my preference is to stop the litigation as early as possible, and I think anything that contributes to that, and it may be that it's too early for mediation, but that usually doesn't derail things, and it doesn't mean that mediation won't be successful later, and maybe it only serves to eliminate a couple of points of contention. But I think it's good to have that external involvement to advance the cause of settlement. But some people would prefer to litigate, and in that case, maybe it's not going to work.
Any other comments, observations on what we've just heard? I wonder, sorry.
Well, Stephen from Laws Legal, just briefly a couple of points. There can be too early mediation and too late. Thanks, Michael. I think there can be too early mediation and too late mediation, but perhaps while we've got some members of the bar here, I think sometimes it's important to stand up to a court which is ordering mediation, which is obviously too early. And just a brief, I'm sure we've all got examples, but a brief example, we basically walked into a court in a federal court matter, and the first directions hearing, and Justice Gordon sent us, was next door to mediate straight away. It was far too early. I think it was appropriate for counsel to make a stronger stand on that. So, as Michael says, I think you need to judge your cases. One of the other points, I think, Paul, you were raising about a mediator giving an opinion. Some of us are braver than others. Well, yes, and perhaps instructing solicitors should also sort of be a bit braver as well. So I think you need to sort of judge each case in relation to a mediator giving an opinion. I think in the hundreds of mediations that we've been involved in, it's happened once where a mediator's given his opinion in the open session, and it was a disastrous mediation. You had nowhere to go from there, and I think we've been fortunate in Victoria. We have generally very good mediators who will tell you at the start they're not there to give you opinion. They'll help test your cases in private session, but never in open session. So, and my view is that they shouldn't give an opinion on the law or what the likely result is of a particular issue. And there seems to be a bit of discussion about this early neutral evaluation. I noticed that the Magistrates Court had set up early neutral evaluation about 3 years ago, and that's slowly sunk into the West. I think there's no take-up. Our firm has been involved in one early neutral evaluation in the Supreme Court. It was not a great success in such it answered a particular issue, but it didn't advance the case any further. And my own view, for what it's worth, is that there is really only one winner out of an early neutral evaluation, but it may not leave the parties anywhere to go if they have a decision from a judge in the court where the matter might be decided later on. Where do the parties go after they've got an opinion from a judge of that court that a particular contract might be decided this way? So I'm not surprised that there's little take-up of it, especially where there's procedures in all of the courts where you can have discrete questions tried early, being fully examined and tested, I think, as Rob has indicated, is an appropriate method of deciding some issues.
Thanks very much, Tina.
I understand the Magistrates Court, this early neutral evaluation pilot is still ongoing this year.
We haven't had it once.
Right.
We won't take it up.
Yeah. I ran into a barrister who was heading off to a early neutral evaluation in the Magistrates Court on a tax matter, and I meant to get back to him and find out what happened, but I hadn't got around to that. But he had no clues about what was going to be happening, so I don't think it's been used very often. But I understand it's Magistrate Braun and Magistrate Lauriston who are doing it.
Well, I think having deprived everybody of the ability, it seems, to partake of morning tea or breakfast, we should probably conclude our discussion at this stage. Those of you who are old enough to remember a show called World of Sport would remember that at the conclusion of the panel, the presenter, Lou Richards, would hand out Patra orange juice and other things. I'm afraid we don't have any Patra orange juice. It's been in administration for many years, Michael, but I wonder if you'd join me in thanking Michael, Mark and Elizabeth for this morning's presentation.